It is January the 16th, and this is the court gallery. Okay. I've already seen in the chat a few people saying I know Judge Webster, but I don't know the other two judges. Yes, you do. We've watched all of them before. The first one is the M80 judge, Judge Rossi himself, and he's got a couple of crazy cases in front of him. One lady is not happy with the state, and she is suing everybody. The other lady, she's got a PPO that she wants dropped, and, well, it's quite a story, and I know you're going to enjoy it. Next, we're going to be going to Kansas crazy. You're not in Neverland anymore, ladies and gentlemen. We're going to see Judge Crum. Isn't that Judge Crum? No, that's Judge Lee. I'm sorry. We're going to see Judge Lee in Kansas, and he has some interesting things to say to a couple of defendants who should let the lawyers do most of the talking, and then Judge Webster, Judge Webster and only the way Judge Webster can do Judge Webster. And there might be a very special something at the very end with our favorite Judge Dad, Judge McNally, who's had a heck of a week. He's going to round it off for us on this Friday edition of the Court Gallery. It all starts right now.
The person signed on is Jody White. Please unmute and turn your camera on.
Hi.
What are you?
Just
what are you here for?
I'm court watching. Just I'm
are
interested
you a
in the
party
topic.
to the? Are you a party
Nope.
in the case?
I'm
okay.
just
Then you'll have
interested.
to. I'm sorry. You'll have to watch on YouTube. Only parties are permitted. And
All right, and
okay.
and I can find it easily. Just go to
accesskent.com. Yep.
Okay, thank you so much.
Yep. You're welcome.
Bye bye.
Bye. Circuit Court for the County of Kent is now in session. Honorable J. Joseph Rossi presiding. We are here in the case of Shannon T versus Department of Attorney General et al. Case number 25-09724AS. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court on motions for summary disposition by the Michigan Department of Attorney General, the Michigan Department of Health and Human Services, the Kent County Board of Commissioners, and the Kent County Sheriff's Department, as well. Therefore, incorporated is the Kent County Health and Human Services Board and the Michigan Department of Health and Human Services. With all that, I would invite appearances by counsel. At this time, I see Ms. Tanis is present, self-represented, I guess. So, Ms. Tanis, why don't you state and spell your full name for the record?
Shannon Tanis, SHANNON
Thank you, ma'am. And counsel, at this time, if you'd place your appearances on the record and the parties you represent.
Good morning, good afternoon, Your Honor. Tyler Kitzmiller, Assistant Attorney General, representing defendants, Department of Attorney General, and the Michigan Department of Health and Human Services.
Thank you.
Good afternoon, Your Honor. This is Michaela Morathi on behalf of the Kent County Commissioners and the Kent County Sheriff's Department.
Very good. Who has the Kent County Health and Human Services Board? Are they a sub-unit of the county commission, or are they a part of the Department of Health and Human Services?
I have the Kent County Commission.
Okay, and the Human HHS Board is a subordinate body, or
No, not for
a
us.
little
Sorry.
not clear to me.
Your Honor, Sangeeta Ghosh, Assistant Corporate Counsel for Kent County.
Yes.
The county board is represented by Michaela. I wanted to clarify that the Department of Health and Human Services is a division of the state Department of Health and Human Services. It's independent of Kent County.
Yes, but the board, it sounds like, falls at least within the ambit of the county for purposes of today's motion.
Yeah, the county appoints 2 board members to their commission.
And that's the Kent County Health and Human Services Board, then?
Yes, Your Honor.
Okay, all right. No, that clarifies that for me sufficiently. All right. Well, I have received both parties and reviewed both parties' motions for summary disposition. Mr. Kitzmiller, I guess since you have less defendants, I'll let you lead off initially with your argument.
Thank you, Your Honor. The state defendants, as I'll refer to them, for the Department of Attorney General and Michigan Department of Health and Human Services, we've filed our motion pursuant to MCR 2.116, C4 and C8 for lack of jurisdiction, as well as failure to state a claim as it relates to my clients, the 2 state defendants. As it relates to jurisdiction, Your Honor, claims such as these brought under the Freedom of Information Act, or FOIA, or the Open Meetings Act, OMA, brought against state agencies or the state itself, fall within the exclusive jurisdiction of the Court of Claims. And therefore, our argument is that this court lacks jurisdiction over those claims and dismissal is warranted. I understand plaintiff has filed a motion for venue transfer, and I'm not sure if Your Honor wants me to get into that at this point.
Yeah, you may address it.
Sure. So as it relates to that, first, our argument would be that it's an improper motion brought under the court rules, as the rule being utilized is MCR 2.222, which is usually or only applies when venue is currently proper, which is not the case here. And so it would be an improper motion to be considered as it's brought by the plaintiff. Nonetheless, even if this court were to consider it and transfer this matter to the Court of Claims, regardless of the jurisdiction or the court that it's in, the claims still are ripe for dismissal at this time, pursuant to C8 for failure to state a claim, as there's no allegations in the complaint or the documents filed by Ms. Tanis as it pertains to the Department of Attorney General or the Michigan Department of Health and Human Services.
Okay. And so that's for a lack of specificity. That is, the complaint simply does not spell out in as many words the violations alleged against those 2 agencies.
Correct, Your Honor. That's our position.
Okay. All right. I think I understand that position. I'll let Ms. Marithi fill in any additional.
Your Honor, and I do just want to clarify that, as Mr. Kitzmiller mentioned, he represents the state defendants, the Health and Human Services Board, and the AG, and we do not represent the Health and Human Services Board. We only represent the county defendants,
I see.
Sheriff's
Okay.
Office, and the Board of Commissioners.
Okay. All right. So your argument here is the HHS board, even though the county commissioners put 2 representatives on it, is really a subset of the Department of Health and Human Services.
That's correct. It's a state board, not a county board.
Okay. All right. That makes sense to me. All right. You may proceed with regard to the county defendants then.
So the county defendants are moving for summary disposition pursuant to MCR 2.116C7 and C8. For the FOIA claim, we are moving for grant summary disposition because plaintiff did not file her complaint within the relevant statutory periods. The Michigan statutes MCL 15.2401B and MCL 15.240A1B require that a FOIA requester who wants to challenge denials to their FOIA request must file within 180 days of receiving a final determination related to their request, and a FOIA requester who seeks to challenge the fees charged in association with their FOIA request must file their claim within 45 days of receipt of a final determination. In this case, plaintiff appealed denials in her FOIA decision that were made by the Sheriff's Department to the Board of Commissioners, and the Board of Commissioners made a final decision on plaintiff's appeal on April 25th, 2025, and plaintiff did not file her complaint until November 6th, 2025, which was 195 days after the final determination was issued by the Kent County Commissioners. And so we are asking that you grant summary disposition on the FOIA claim as it is time barred under the relevant statute of limitations for both fees and denials. As to the OMA claims, similarly to the state defendants, we note that plaintiff has failed to state a claim against both the Sheriff's Department and the Board of Commissioners. Her complaints and pleadings do not implicate them in any meaningful way, and she has not alleged any specific violations of OMA by either defendant.
Okay, all right, very good. Let me hear from Ms. Tannis in response to these arguments.
I'm a little overwhelmed by the back and forth with the responses put on the record. One, I stand on what I filed regarding jurisdiction of the local health and human service board and the state claims. It's clearly states that you can file in the circuit court regarding these matters, and that the motion for transfer of the venue to the Court of Claims is exactly per the court rules. So I stand on that. Secondly, why I did this FOIA and why I started engaging the health and
Ms. Tannis, your audio is breaking up a bit. It might be possible, since I've seen you and I know you're present. Yeah, if I could interrupt you, Ms.
Of fraud, waste, and abuse.
Ms. Tannis, I'm having a very hard time hearing you.
My daughter's situation.
I understand.
And I asked for
well, so I can hear you, Ms. Tannis.
When I did this, that they were not going to be willing.
I was going to say you could possibly turn off your video so I can just hear the audio. Sometimes that makes it more clear.
Yeah, hold on. Okay, hold on.
Much better.
Is that better?
Much better.
Okay. So my request and engagement regarding this is fraud, waste, and abuse, and to protect vulnerable people. And I knew that the body was not wanting to give me information to support what happened and to prove my claim. So I knew that they were going to violate, okay? But when there's fraud when you're requesting government transparency investigation from law enforcement regarding fraud, waste, and abuse, it has a higher interest and authority, and these things don't apply. Okay. I don't understand why these things have been allowed to go on and impact me and my family the way they have, the connectivity. And in fact, regarding the current status of the Attorney General and her office being in question with breach of firewalls and conflicts of interest, it's very important that there's disclosure if anyone tied to the Attorney General has a personal relationship or any of that matter that could have a connectivity to that. Because I have been advocating and directly towards Dana Nessel regarding addressing fraud, waste, and abuse. Okay. And the harm that's been allowed and the amount of stuff that I've had to go through and the amount of complaints that I have filed to the Attorney General's office and that have just allowed to be slipped through the cracks is very highly concerning. Okay. The amount of government connectivity and individuals that are involved with the impact of harm upon me and my family is outrageous. Okay, there has to be some accountability, some addressing of the deficiencies that are going on that allow these things to continue. You do not get to use every exemption, everything in your positive power to deny a claim or to address these matters. They're the highest importance, and the law even states that. The interests for the public and for the government regarding these matters are of the highest importance. So I don't understand why any of this is allowed to be fruitful from their standpoint. Even if there is a statutory limitations, it should not be allowed to be applied in these matters because of the importance and what I'm trying to address here.
Okay, well, I think I understand your argument then is one based on public policy, and you're saying, Judge, even though I may have not technically complied with the statute of limitations, contained in the law, that your interest in overarching the public policy and the transparency required of state agencies should trump that, and I should, I guess for lack of a better term, give you a pass on.
No, I'm also stating on what I filed. Tolling applies in this instant based on the response from the body, even though they did not cite it or they call it that. It was left open-ended. Okay, this process, what happened through this FOIA, they're asking me to basically be a psychic and to predict whether it's going to be fruitful or not. Okay. Not to mention that they use delay in this process to their advantage. And because I'm not a practicing attorney, there's supposed to be a enormous amount of leeway for that. Okay. There's every avenue that I've tried to get someone to help me to address these claims, an attorney, it's not successful in any matter that I try to address. Okay. I have to learn as I'm going along. And at some point, even if you decide to deny my claims based on their motions, I will learn from this. And at some point in time, I will master this and catch somebody to a great degree. Okay. And when it does happen, no one's going to be able to deny it. Okay. But
I understand, I think, correct, that you believe there's wrongdoing here. The difficulty I face from where I sit is, of course, I've sworn to uphold the law, and that includes the statutes. I'm not allowed to rewrite them from where I sit or remake them in my own image. I can give a pro se litigant like yourself some additional leeway on particularly procedural rules and things that normally, for example, the form of the pleadings and the way they look and stuff like that. I can give you some leeway. However, I also have to uphold the portions of the law that are substantive, that are not procedural, that have some sort of barring effect. And I can just a couple of general comments in that regard, Ms. Tanis. And first of all is, I applaud your eagerness to see the government be transparent. Everyone does, and I certainly understand frustration that it appears like when it trying to achieve more transparency, you often run into a brick wall of, we're transparent, but it's going to cost you X dollars that you may or may not have. And B, yes, we're transparent, but you didn't, format your request in exactly the right way. So you don't get the benefit of that transparency.
Well, here's
that's
gist, Your Honor, here's the gist of the situation. It is not a year from the date of when these incidents occurred, so I can turn around and file against the bodies again directly regarding the matters that happened, and allowing a facility that is under state funding and has state cameras in that home is guised as a sober living facility, allowing this kind of conduct and contributing alcohol to minors and having guns and threatening people because of the fact of filing child support for a possible parental establishment and support. It's just insane. Okay, so I will succeed in some kind of capacity. They will have to answer to this.
And the facility, what facility are you referring to there?
The address that's in my FOIA. And the individuals that are listed are the people that are running it. And one of them is the father of my granddaughter, sir.
And is that facility in the state of Michigan, or is it elsewhere?
Yes, it's in Lowell. It's in Kent County Sheriff's jurisdiction. That's why they kept responding out there.
Okay. Well, I'm not familiar with it. And I mean, obviously, the whole issue of child welfare, those issues, which are civil rights issues or criminal law violations that you've raised. And my understanding is, at least from reading through the pleadings here, that you have made some contact with the prosecutor, but have not, had the prosecutor take up the case yet. So.
No, sir, that's not what it. No,
you haven't been in contact with the prosecutor's office, or?
The prosecutor office contact that I'm citing is that I inquired about a gentleman that died in a tub in a foster care facility, and it was from the burns. Okay, and I talked to the detective, and the detective told me he talked to Chris Becker, and Chris Becker told him he was not going to prosecute the case, and it was because of the fact of the connectivity of the people running the nursing home. It was to cover up the fact of the people that were running it.
That doesn't sound like Chris Becker that I know, but when
I called the office and I talked to the girl, I have it recorded. She stated their office does not have an official file on that case, that it was reviewed and denied for prosecution. Okay, that's what I'm talking about when I cite that in my claim. Okay.
Well, but you didn't bring any of the other matters that you're talking about, that is furnishing alcohol to minors, et cetera, at some state operated or sanctioned facility. You haven't brought those to the prosecutor or filed a police report?
The sheriff's office, when the incident happened last year, I at the time of it, I told them to investigate me, and I gave them evidence that my daughter was being coerced and she was being held inside of the house. That's what I'm trying to tell you, sir. I had to use FOIA and use OMA because the public bodies are not addressing these criminal activities and highly concerning ongoing This is just highly disturbing. So these people tried to claim that my daughter was living there, and they convinced the sheriff's office that that was her permanent residence, and it wasn't. My daughter was only there for like a week and a half to connect with the father because he had not even known about his daughter. Okay. My granddaughter's going to be 4 in March, and I had to tell the sheriff's officer that was whatever they told them was a lie. They tried to tell them that my daughter was seeking refuge from Muslims, okay, like terrorist activity, that she was there under asylum type of, yeah, there was a whole thing. The guy running, Jake, that's posing as a pastor, that's running this sober living facility, he called me, told me I had to come and get my granddaughter at the King County Sheriff's Department with CPS and all that stuff. And none of that came to fruition, okay? So I'm like, what is going on? There was this whole scenario that happened. It was just crazy. And I'm trying to figure out how this was allowed and if there's a history of this going on and who these people are. Okay.
Yeah. Well, here's my thought on that, Ms. Tennyson. I have, I can't speak to your specific situation. Obviously, I only know what I read out of this particular file, but I do know that any legal matter that comes before the court or is investigated by law enforcement, ultimately prosecuted or not, they're inherently very fact specific as to that specific incident. The idea that perhaps there's some pattern or history of wrongdoing by the higher body, certainly worth investigating. And heaven knows if you research nationwide, there's been ample evidence of various public bodies committing wrongdoing. However, the way, going about it, particularly through Freedom of Information Act and other requests, it's expensive and can be unwieldy and unfortunately very constrained by the statutes themselves. So
Yes,
I understand your frustration, but I do have to uphold the law in this situation.
Your Honor, if you read into the lien the exemption that I applied with the lien user agreement, it says there are exemptions to this. The citation that the Sheriff's Department uses for exemption to give me information, if you read further in, it cites these issues does not allow the public body to withhold this information. Okay.
I get it, and they have to comply with that, and of course, they have to comply with the law. But I'm constrained by the, parameters of the statute that you're requiring under. So,
okay, but
let me issue my opinion in order on the record. I understand you may disagree with it, but fortunately, I get reviewed as well. It's entirely a legal opinion, and
yes,
that's
I
what the Court of
understand, Your
Appeals
Honor.
is there
But,
for.
okay, before you do that, since you're aware of this issue of government bodies and things not being done, can you please answer to why the fact the 17th Circuit Court is trafficking my daughter through the juvenile division with a current open case and they haven't had any contact with her?
Yeah, no, and I can't, I am not in the family division of the court.
But
Judge
this is
McNabb, this is the 17th Circuit. I am a judge there. However, you're in the civil criminal division for the purposes of this argument right now, just because this is a civil case and falls under that way we classify cases. Any decisions made by the family division of the court, which is the juvenile division as well, would be answered by the judge assigned and ultimately, the
actually, there's
responsibility of the
time
Chief Judge
frames.
McNabb.
Yeah, there's time frames that flag on the case for non-activity and things like that. So I'm just kind of wondering how they bypassed that and why the higher up courts haven't caught that.
No, and I can't answer that question, although I can tell you that any decision by the family division of the court is also subject.
The state's going to have to, the
Appeals.
state's going to have to answer to that too.
All right. Well, and obviously there are a lot of moving pieces here, but for my purposes of the ruling is that the local
You're going to
agent,
grant it. Yeah,
T's involved, I'm going to grant summary disposition, and that's because the appeal here of the decision of the Kent County Board and the Kent County Sheriff's Department is simply untimely and therefore barred by the statute of limitations contained within the Freedom of Information Act itself. And that's specifically Michigan Compiled Laws 15.240 parens 1 parens B, requiring the issue to be raised within 180 days of the final decision of the written notice. And that's the applicable statute here. And in this instance, that was not complied with. That ran and this appeal was filed significantly after that time limitation. So pursuant to MCR 2.116C7, then the motion against the two local bodies, the Kent County Board of Commissioners and the Kent County Sheriff's Department is dismissed. With regard to the Department of the Attorney General and the Michigan Department of Health and Human Services, and then the subsidiary board, the Kent County Health and Human Services Board, the motion is also must be dismissed. First, this court lacks jurisdiction, as pointed out by the Attorney General. Actions against state bodies are to be filed originally in the Michigan Court of Claims. So therefore, it is to be dismissed under 2.116C4. There is an argument contained here that I should change the venue to the Court of Claims. However, that is only applicable when the venue is correct in this court, which it never could be in the case where original jurisdiction lies in the Court of Claims. So the claims against the state bodies involved, that is the Attorney General, the Department of Health and Human Services, and the Kent County Health and Human Services Board, a subsidiary organization of the State Department of Health and Human Services, are dismissed pursuant to MCR 2.116C4, there being no jurisdiction in this court to decide those claims. And this will be a final order and close this case. Therefore, that triggers your timing on appeal, Ms. Tanis. So if you do want to appeal my ruling today, you do need to file notice of appeal and obtain the transcript of my order today in order to timely file that with the Michigan Court of Appeals. Anything else we need to place on the record at this time? I'll go first to the Attorney General.
Yes, Your Honor. I didn't want to interrupt you, but I do want to clarify the only two clients of mine are the Department of Attorney General and MDHHS. The local board is not my client.
It's an independent board, perhaps. I just hate to have a floater out there that my ruling doesn't address. So I see that on corporate counsel sounds also at least uncertain if they own the board or not. They appoint members to it, and I'm not familiar enough with that board to know what their standing is. It does seem to me that they are a public board, and the name Health and Human Services is one I associate with the state, although I'm well aware we have a Kent County Department of Health and Human Services as well. So fair enough. I'll just allow you to do it with regard to the two state parties that you represent. I'm uncertain as to what's going to happen with that Health and Human Services Board. I'll see if any answer for me on that, Ms. Marithi.
Your Honor, I did just want to clarify that we also moved for summary disposition under MCR 2.116C8 for the Open Meetings Act claim, and just wanted to clarify that you are granting that as well.
Yeah, I'm granting it on C7 specifically. Let me flip to and the Open Meeting Act's claim under C8. I'm sorry, you're right, Ms. Marithi. I address that, and that is because, right, they would require the naming of a specific individual that failed to comply with the Open Meetings Act rather than just simply a broad allegation of a failure to comply with the Open Meetings Act, and further fails on specificity. Is that correct?
Yes, that's correct.
Okay, yeah, then it's granted both under C7 and C8 because the C8 is applicable only to the Open Meetings Act. I guess I was focused on the FOIA Act and forgot there was an Open Meetings Act claim in there as well. Who's going to draft me? Are we going to get two separate orders on this from the AG and from the county?
That may be easier.
Yeah,
That's what I think. Let's do it that via two separate orders, and that will you can both submit orders with copies to Ms. Tanis, please.
And do we just mail those to the court, Your Honor?
Yes, or you can file them electronically via our new electronic document system. So, but make sure you mail a copy since we do have a pro se plaintiff here, Ms. Tanis. Make sure you mail a copy to her at her last known address. Ms. Tanis, do we have a solid mailing address or an email address where you can receive copies of the orders?
Judge, she either logged off or we lost her and she hasn't tried to join back in.
Okay, well, we'll just have to go in with the last. I do have an address on her pleadings here on 44th Street Southwest. We'll just have to go with the last address. Thank you all.
Thank you, Your Honor.
Thank you, Your Honor.
Circuit Court for the County of Kent is now in session. Honorable J. Joseph Rossi presiding. We are here in the case of Alma Murdanovic versus Camille Topolovic, case number 24-03073-PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this comes before the court today on respondent Ms. Toplovic's motion to modify the current protective order. Ms. Toplovic is present here today, so I will swear you in and hear your argument for modification and then make a ruling. So if you'd please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, Your Honor.
All right, very good. And first of all, you said there was a defect in the notice regarding the extension of the PPO?
That is correct, Your Honor.
Okay, and how did that explain to me how that occurred?
So, Your Honor, I was going through a really tough time in my life, and I made some very bad choices at that time where Miss Alma, had extended the personal protection order. The address in which the PPO was sent to my father's address. I was in a legal dispute with my father at the time. And duly noted, I was evicted from my main residence of August of 2024. So I needed to use my dad's address for mailing purposes because I did not have an address. So it was sent there. But at the time that it was sent, there was a legal no contact order. My dad accused me of stealing money from him. So because of that, I was set out on bond. I never got arrested, but there was a no contact order in place. I was not to have contact with my dad who resided at that address, and I could not have any contact with the address as well. This lifted in May of 2025. That dispute has since been solved. He found the money that he thought I stole while I was staying with him at the time. So those charges were dismissed entirely. There was no, there's no like settlement or like diversion or anything like that. I showed up to court once for an arraignment and then it all got dismissed. So I knew something was wrong when Alma tried to serve that PPO violation to me at the end of April. And I did not get the official extension paperwork until the end of May when I was able to have contact with my father again. So, and at that time, that's when I tried to file a motion to terminate because this PPO is not necessary. And any of the evidence that Alma has provided, I have never tried to contact her. I have never tried to threaten. I've never threatened her. I've removed Alma from my life several times, and every time she messaged me wanting to be my friend again. I do not know how this escalated the way it did. I am not sure if you have access to the evidence that I provided in the motion that I filed a month ago or so. She is using her social media to harass me, and she is using this PPO to harass me. Alma does not need protection. In any of the evidence, I know, Your Honor, you mentioned last time Alma and I had a hearing, you did not want to modify it because the chief judge is the one that granted the PPO. I also filed a restraining order on Alma at the end of 2024, I believe, when she was still harassing me through her social media. That PPO got approved by the same judge that approved hers for me.
Judge McNabb approved yours as well?
Correct. Yes, she approved
Okay.
my PPO for Alma. There was a hearing because she contested it. And at the time, Your Honor, I can't tell you why I didn't show up. She hired a lawyer, and I think I was very intimidated because she did get a lawyer, and I did not have money for a lawyer. I just went through an eviction. The father of my children was in jail for domestic violence. He's still in jail right now. So it was just a lot going on, and I did not prioritize this the way that I should. In the evidence that I have included, Alma is posting about me in my workplace. That is very clear. Alma is logging. I don't know what account she's using because I have all of her accounts blocked. She is reporting my content on Instagram to get it taken down. And that is part of the evidence that I included when I filed the PPO on Alma in 2024. At the time, with her rebuttal to that PPO, she said, I didn't report anything. Instagram detected the copyright and took it down. But this year or last year, when she tried to submit a PPO violation against me, she claimed she posted screenshots with her and a friend. And in these screenshots, she said she reported this post last year because her friend sent it to her to let her know that I was copying her. So here we can see that there's some discrepancies with Alma's stories and that she's pathologically lying to try to make me look like the instigator when I am not. Recently, just 2 months ago, if that, she logged into her business account on Facebook and laugh reacted at my pictures. I know that this is her business account because when I was able to access the account and click on the account that laughed at my photo, there was pictures of her and her boyfriend promoting their solar business. So on top of her reporting my content, on top of her laughing at my post, all while the PPO is in place, she also posted a conversation with her and a mutual friend talking about me and the way I look at where I work, which is Cooper's Hawk. Everybody knew that it was about me, and that's why they screenshotted it and they sent it to me. Your Honor, this is not behavior of someone who fears for their life, for someone who is fearful of another person. And my mentioning of me filing this restraining order on Alma, Chief Judge Deborah McNabb approving it, I copied and pasted the same exact way I petitioned that order and submitted a new one 2 months ago, and they did not approve it because there was no significant evidence of there being any type of harm from me to her, and there was no 2 pieces of unwanted contact. And
was that also Judge McNabb who denied the
no,
newer application?
it was Judge West.
Okay.
I think it was Judge West because I believe McNabb is not doing PPOs anymore from what the PPO office told me, because I was very confused why I would get the same exact PPO approved, and then a year later when I try to submit another one, it gets denied when I filed it the same exact way. And their reasoning for it being denied is because there was no evidence of
different judge. No, it is, they do vary because different judges, there's a lot of discretion in the statute, and different judges will apply, a different, even though there should be a common legal definition of harassment, et cetera. Another factor that could be there that I consider when I get a PPO that's been filed a second time, or where a person has filed a previous PPO, is I make sure that I'm not using anything that was ruled insufficient in the previous PPO to justify, because we do want to make sure we preserve the finality of previous rulings and say, okay, those are then out. And then I have to look at only new evidence to see if it justifies a subsequent PPO. And that's how I do it, although I can't speak to, I know Judge West does have a docket of these, but I don't know, his mental thought process. So, the reason I went to the service issue was because, if there was a technical defect in service, I might be willing to reconsider what Judge McNabb ruled, but because she is the chief judge and she extended it, for the same reason, I am not interested in effect, overruling her and saying, I'm going to shorten up her decision that it should be extended for 3 years. My only piece of advice, since you do have, or no, but you didn't appear for the objection, so she then denied the PPO on the objection by the petitioner in this case, but she was obviously respondent in the other case. So you don't have a PPO where you could file a violation. The only I guess advice I can give, is to continue documenting. I will say, when I struggle, and you'll find this among the bench, since we tend to be, for the most part, older, and are, in my case, 60, and Judge McNabb also on the older end is, I have I struggle to understand the mechanics of how the social media interaction works, and that I know that people are having, what are in effect conversations on social media, and that blocking, objecting to the platform and having something removed are all ways of communicating by social media. And that's about the depth of my understanding in terms of how much of my own information I'd have to identify to accomplish that, and how personal, in other words, it would have to be to accomplish something on social media. I very much struggle to comprehend that. Simply just I don't do it enough myself to be familiar with it, and that's the I imagine an obstacle, so I struggle with it not only in your file, but in any case where there's a lot of social media involved. I tend, like most judges do, I said, well, if someone cusses someone else on there and, says I'm going to come over and beat you up with a baseball bat, or, I also use the F word rule. I said, if you use that more than 3 times in a conversation, then, those are easy ones for me. But, short of that, with more nuanced interactions on social media, I really do struggle to see, how targeted that conduct is, and how offensive, I guess, it would be, too. I guess I think of a copyright thing and I think, well, if Instagram took it down, Instagram must think there's, well, they're worried about their exposure to copyright. They're not so much, worrying about protecting, another person as they are someone suing Instagram, for a copyright violation, and Instagram getting caught. So, I understand some of the legal nuance of it, but I don't understand very much of the technical stuff on the social media. I do also totally understand, particularly in current businesses like you seem to be operating online, and it seems like she has a business presence online as well, that it's probably totally essential to be online. So, I used to say, particularly, in Facebook and messaging and instant messaging and things like that were such a thing, or Snapchat, I would say, well, just take a break from that stuff. You don't pay any attention to it. But if you're trying to run a business, obviously that would be fatal to your business. So you got to maintain the business website, and it is certainly irritating. But I can say not always actionable. Particularly, the PPO is a very targeted tool to use, but it also has limitations to it. And I think, that's what you're hitting up against here, along with judicial limitations, and that I rarely grant anything more than a 1-year extension on a PPO because I recognize, we don't give the same kind of process to a PPO that we do to a criminal charge or something like that in court. So I make them shorter, but the chief judge has a different opinion of that and grants them for longer than I do. But you can, you could request, and if you really wanted to spend some money on this, you could, file an appeal with the Michigan Court of Appeals saying that, you don't think, you think that's an unfair deprivation of your liberty because it's so long. I can't tell you it'd be a great case, and frankly, the Court of Appeals isn't a whole lot more eager to look at these things than the trial court judges are. So they might not even take it up, and I'm not even sure if it'd be timely at this point. But for the moment, I'm just going to have to leave it in place. It sounds like you've done everything that you can to kind of follow the legal system to counter this. And, the one thing that hasn't happened with either you or the petitioner here, and what troubles me in these cases sometimes too, is when someone ups the ante, they say, well, I'm going to move it from social media to, I'm going to go break a window, do something stupid like that. And as you have learned, from the encounter, in the whole situation, because, it sounds like the system actually worked with regard to your dad's untrue allegation against you that you took something, that ultimately the prosecutor dismissed it because the evidence wouldn't support it. But you don't want to give the other side any extra ammunition in a case like this, or they would undoubtedly use it to come after you. So all I can advise is, keep steady, keep the peace. Keep your business running. Do know that if I was out shopping for a business and I saw a reaction like that, I wouldn't know if it was good, bad, or otherwise. If it's any reassurance that at least in my age group and demographic, half the stuff that goes on the online like that, because we're not so aware of the intricacy of it, I don't pay a ton of attention other than I might read a review of a business by someone who's a customer or something like that underneath, but I don't in terms of more nuanced reactions. I can say I don't pay very much attention to it. So I'm hopeful that, you can go on, conduct business, do what you're trying to do on your side as best you can going forward and not running afoul of the PPO. But I can't give you any relief on Chief Judge McNabb's ruling, because to do so would be in effect overrule her, and I'm not willing to do that. So.
I'm not sure if this changes anything, but I'm not running a business on social media.
Oh.
She used her business page to
react to a personal thing that you posted.
Yes, a picture of myself, a selfie of myself. And Your Honor, I genuinely think when she filed the extension, she mentioned that I sent my partner to her work to intimidate her, and that is a lie. I was never able to counteract that and bring him in as a witness, because the reality of that situation is he went to her work to serve her my PPO, me fighting her PPO. And
the legal paper. Yeah.
Right. She asked him to stay until she was done with a client so she could talk to him about the situation. That, if she was intimidated, she wouldn't have done that. She over-exaggerated everything in her extension so she would be able to get this extension granted.
Yeah, no, and all I can tell you is that's probably par for the course in the way that, these PPOs play out. And the other piece of that is that the judge deciding it, and I put great stock in, who shows up for the hearing and, makes the argument or doesn't make the argument, as I know Judge McNabb probably does as well. You can only go on the limited facts that you have in front of you at the time. So, they are kind of an area of the law where you get the least, compared to, for example, the criminal case where, if you plead not guilty, you're going to get the full due process protection of the law. That's not as true with PPOs. And the reason it's not as true is because, at least in the grant of the PPO and the keeping of the PPO in place, the stakes are lower. Now, if you get charged with violating one, either criminally or and asking for criminal contempt for violating one, then you do get all those procedural protections again. You do get the right to a trial and an attorney and all that stuff attaches. But at the stage you're at, they get the kind of least scrutiny by the judges. And, the very statute forces us to make a decision on them within 24 hours. So we're making faster decisions than we're used to on very limited information. So the good news about it is, though, is, the PPO doesn't appear, it's not a criminal record or anything of that nature. So, in terms of conducting official business, whether you're applying for a lease or loans or school, whatever it might be, you don't, unlike a conviction where you do have to disclose, a felony conviction, you have to disclose, you don't have to disclose if a PPO exists or not. It's a civil matter. So, and when it goes away after 3 years, it really will go away. It won't, because you can only grant them for up to 5 years, and this one will be in place for 5 years by the time it runs out, after the remainder of the time. And I don't think there will be any more extensions. So, insofar that there's a little bit of light at the end of the tunnel, that's the only reassurance I can give you at this point.
You are right about everything, except the military. The military can see it. I am trying to join the military at the time. The father of my children has tried to kill me twice now, and I'm trying to escape. I'm trying to leave this state, and I feel like the military is my only option because I don't have money and I don't have resources in other states other than the military. And that is why I was in the Marines 10 years ago. I am wanting to go back in, and this is, I had a motion with you.
Yeah, I modified it so you could
Yes.
carry a weapon if necessary and if you need anything else, which services are you looking at?
I want to go Air Force.
Yeah.
I tried to go Air Force. They don't, since it's standing, they said that they won't do it because it's considered an open court case. And I tried Army, and they're saying the same thing. So I think I'm just not going to be able to do it until it gets shortened. And since, she's displaying behavior that does not reflect someone who's scared of another person, someone who requires protection. I just filed a restraining order on my ex-husband for trying to kill me.
Yeah, I was going to say that sounds like a case where definitely one would be justified. So
exactly.
Yeah.
So I really don't understand.
Get one there for the military. If there's anything I can do, in terms of explaining the limited nature of the PPO or writing a letter, something along those lines to assist with that, I would invite, if you want to, tweak the Air Force people or whatever, and encourage them to reach out to me, or you would reach out to me and put me in contact with them or whatever. I am a veteran myself, so I support people joining when they are able to, and would be glad to explain it, because it's not an open court case like for example, you could have a judgment against you for $250,000. I get why the military wouldn't take you if you had a big civil case going or something like that, but a PPO is kind of a placeholder. It doesn't mean you can't leave the state. It doesn't place any restraints on you except any contact with that other person who's not in the military. So but I also am not up to date. I never was a recruiter, so I don't know what their requirements are. So but I would be happy if there's any way that I can explain or assist with the military process. You going through that. Well, I do wish you luck. I'm sorry I can't grant you relief at this time on that particular issue, but I do wish you the best of luck. And you do have a lot of irons in the fire and a lot of things going on in your life, and I wish you the best of luck. Are you able to get assistance, counseling, and things like that if you need some emotional or mental support, like just about anyone would with a death threat and a PPO and matters like that?
I'm kind of working on it right now. I'm focused on just moving, so when he gets out of jail, he doesn't know where I live.
That makes sense. How long does he have in?
I have no idea. He has not been sentenced yet. This just happened within the last few days again.
Got it. So he's in custody now, so he could bond out for that matter.
Yeah, and I know he doesn't have money. He doesn't have a lot of family here, so I don't know when he's gonna get out. So my main focus right now is to get out of this apartment as fast as possible so he doesn't know where I live when he does get out.
That makes sense. Have you reached out to any of the domestic violence shelters, Safe Haven, or there are some. If you go there, yeah, no, that I've heard that before too. Although at least if you get your name on their wait list, if something comes up unexpectedly, possibly, that would be an option. And temporary, boy, those options aren't great either. It would look something like a cot on the floor at Degage Ministries downtown, which wouldn't be. Do you have kids?
I have 2 children.
Yeah, I would go for one of the longer term things, not the Degage. You can't bring kids in there. Which court is the case against your ex in?
61st District Court.
Yeah, well, certainly the prosecutor and the judge ought to grant a no contact order in there from the address and from you specifically, so that at very least, you got a piece of paper between you and him, and he knows he'll get thrown in jail again if he comes anywhere near you. I would ask for that. And if you're really worried about it, ask the prosecutor if they can request a tether condition on bond. I often do that. And they can set that tether so it alarms if he's within like a 400 meters of your residence or whatever. It alerts the police, and it can alert you too. So, there are some good protections out there, and I do, like I say, I don't envy that situation, and I wish you the best of luck trying to maneuver it. I think your strategy of just simply changing address so that he doesn't know where to locate you in the short term is a solid strategy. I've seen many victims do that. So,
And as far as Alma harassing me on social media, she just allowed to do that, and I can't do anything about it.
Continue to document it. The more specific you can tie it to her, and the more it escalates, particularly, I did notice there was one that you said on there that's, where she calls you a bitch or something.
Yes, that was her. And
yeah. Document it, trace it back, and then once you get to 2 again, you can request another PPO. Now, she's going to object to it. And if you do that, I would get more than 2 incidents. The requirement's 2 incidents. And then when you go in, explain to the judge that there's been this ongoing, because they're going to be able to see that she's got one against you, and explain there's this ongoing harassment, and then point very specifically to those instances and see if you can get one granted protecting you too. But, I would say, though that's irritating, your ex is dangerous. So I would prioritize getting the safety you need from your ex first, and then worry about the irritating part second, just to keep you and your kids safe.
Yeah.
All right. Well, I wish you the best of luck, ma'am. Sorry I couldn't help you out today, but I wish you the best of luck with all those. Those are hard situations. I can say if you do need counseling and you don't have resources at the moment, you can. They've got a drop-in center down at Network 180 off Fuller Avenue. And you can go in there and explain what you're going through, and they can arrange for some Medicaid financed counseling services right there, just to help you, be the mom you want to be and stuff like that while you're going through this really hard time.
Okay, thank you, Your Honor.
Yep. Good luck to you.
Thank you.
This is the Butler County expedited misdemeanor docket for January 16th. For January 16th, 2026. First case we're going to call is State versus Nathan Carter, case number 20 CR 359. Counsel, I was going through the case notes, and I only have case notes from looks like September 11th of 20 until April 24th of 23, and the clerk is attempting to forward those to me, but if you'd state your appearances at this time, please.
Your Honor, Darren Defendant on behalf of the state. Your Honor, Chris Pate on behalf of Nathan Carter, who appears via Zoom from the jail.
Right. Counsel, as I noted, I was waiting for those notes, but are there any announcements to make at this time?
Your Honor, I've discussed the allegations with Mr. Carter. He's prepared to admit that he's in violation of his probation today.
As cited in the motion?
Yeah, in the affidavit filed on August 20th of 2025.
Mr. Carter, have you had an opportunity to discuss this with Mr. Pate?
Yes, sir, Your Honor, I have.
And do you understand that you're entitled to a hearing on whether or not you violated the terms of your probation? The state would have a burden of showing by a preponderance of the evidence of violations before the court could take any action on that. You understand that?
Yes, sir, I do, Your Honor.
And by announcing you're admitting to those violations, we would then proceed on to disposition, and you'd be waiving your right to evidence on that matter.
Yes, sir, Your Honor.
Has anybody forced or coerced you in some fashion to make that decision?
No, sir, Your Honor.
Are you under the influence of any medications or intoxicants, anything that makes it difficult for you to think clearly?
No, sir, Your Honor.
Very well. I will find that Mr. Carter has violated the terms of his probation as stated in the the court services officer's motion or the affidavit in support of that. Make sure I've got that here handy. All right. So I'll hear recommendations at this time, beginning with the state.
Well, Your Honor, the original sentencing order was a 9-month underlying sentence, conditions of probation laid out there as well. But you know, one of the concerns that the state has here was one of the greatest violations that we have in probation is failing to report. Not checking in with a court services officer, so there's no workable plan for them. I'm also trying to find a copy of the affidavit, Your Honor. If the,
it looks like August the 20th of 25.
Yeah, it looks like okay.
Part of the court record.
Also had a couple other different violations of the law, a couple of thefts that were part of that as well. Judge, I think my recommendation would be that his probation be revoked and then he serve the underlying sentence. I don't find much rationale to mitigate that recommendation here today in looking at the affidavit. So there were a matter of costs and fees associated with the case as well. I want to make sure that those are paid up or turned over to collections as an order of the court, but those are going to be the recommendations of the state today.
Very well. Thank you, Mr. Pate.
Your Honor, Mr. Carter has been in, he said, for 32 days awaiting this hearing. I think he also had some other credit for time served on this prior to sentencing. He is on probation through Sedgwick County Court Services over there, I believe. He's been reporting on those. He had indicated to me he was working or hoping to get this case transferred over to Sedgwick County to make reporting easier. He is living over in Sedgwick County. He has employment at the Wendy's on Greenwich Road over there. So I think he's doing some positive things. He is on a probation over there that as far as I'm aware, he's compliant on that. If he could get out in the foreseeable future, would be able to go back to his job and work there. So I would ask the court consider some type of sanction on this case and then reinstate and authorize a transfer to Sedgwick County so he can just report on all of his cases over there, that would seem appropriate. In the alternative, would ask the court to consider a downward sentence modification on this if the court would be inclined to impose the sentence, but our primary recommendation would be for a sanction and reinstate.
Very well. Trying to locate the actual sentencing date
December 6th, Your Honor,
of
2024. Of 24.
24. Okay, thank you. All right. Yes, I do see now the journal entry from the December 6th of 2024. I will hear Mr. Carter, if you wish to make a statement to go along with what Mr. Pate has argued on your behalf, you may do so at this time.
Well, Your Honor, I have been trying to walk this probation down. It's just, stuff happened and it was just a mistake.
Well, Mr. Carter, and looking, your first appearance was supposed to be September the 11th of 2020. You failed to appear then, failed to appear almost a year later, or actually a year and a day later, when apparently you'd been picked up on a warrant. Then in January of 23, you were present because you were at the Sedgwick County Jail. Failed to appear in February of 23. Failed to appear on February the 10th of 23. Has anything ever been paid on this case?
No, sir, Your Honor.
Well, I'm going to find that you violated the terms of your probation and revoke you and ordered you to serve the underlying, that looks like a 9-month sentence minus whatever jail credits you have on this case. I'm looking through that journal entry. It does not indicate if there was this was concurrent or consecutive with other cases, but this history here, just nothing indicates that he's any, even really the appearance of trying to do what he's been ordered to do for probation. So the alternative is to serve the sentence. So that's this court's order at this time. Anything further, counsel?
I'd ask that the court order that the costs in this matter be turned over to collections.
Mr. Pate?
And Your Honor, would the court consider a sentence modification or authorization of work release since Mr. Carter was employed?
Where is this employment and how long has that been in place?
It was at Wendy's over on Greenwich in East Wichita. I'm unsure how long he had worked there, but that was where he was working when he got arrested.
Mr. Carter, how long you been at that job?
It's been 2 months now.
Well, I'm not going to modify the sentence. certainly nothing from his behaviors on probation would warrant that in my view. So I'm not going to grant work release to go to a Wichita fast food place if there is a program with the Butler County jail for work release in Butler County. I have no objection if he meets their criteria, but he'll be under he would need to be under that program. And Mr. Carter, if that does work out to where you can do that, then you need to understand that if you're released to go to work and then don't come back, that's considered an escape and would be a new charge that you wouldn't want to have. So please, if there is such a program and you're in it for work release, but I'm not going to approve it for him to go to Wichita for a fast food job. I think he can get he may be able to get similar work there in El Dorado from the help wanted signs that I've viewed. So that motion is denied. In regards to these matters, there's been plenty of time for him to make an effort to pay. I am going to send any outstanding amounts to collections at this time. Anything further?
No.
Very well. With that, Mr. Carter's case is adjourned. State of Kansas versus Isaiah David, is it Dykus Sulzman?
Yes, Judge. He's in custody.
Your Honor, this is the one that we have the victim's parents in the waiting room.
Okay, before we let them in, all right, we've got 4 cases. Obviously, these are all adult cases. Is the victim or victims, are they 18 or older, or were they a juvenile at the time of any of these offenses may have occurred?
Judge, I'm trying to, one moment, Your Honor.
Well, people can attend court by the YouTube facility, and people often do that in cases they're interested. If there's going to be a plea and a victim would have the right to make a statement, but they need to be a statutory victim.
Judge, if there's going to be a plea in 25 CR 337, which is a violation of protective order, from 25 DM 2350 in Sedgwick County, I really don't know who that person is. I just know there's a case there. It says it's Sidney Clark, who is.
That was the stated victim on that. What about okay, that's one case. What about these other 3 cases?
He's also going to plead guilty in 23 TR 3035. The other 2 cases were being dismissed by agreement.
Okay. Okay. I was looking at the traffic case. What was the one on the what was the other case number?
25 CR 337.
Okay.
Your Honor, the victim's parent just messaged me and said that the victim is there with them, and I do believe that they got the Zoom code from Jackie Green, the victim coordinator.
Well, the victim is able to be there. If there's other people with her, they may not address the court. The victim, if she was an adult when that occurred, she's a statutory victim. Her parents would not be, well, they certainly can attend and the hearing. They're not to they're not a statutory victim, so I'm not going to allow them to address the court.
And Judge, from the date of birth, it looks like the Sydney Clark is about 25.
Okay. So, Jen, she can be brought in. I'm going to start with this traffic case 23 TR 3035. If counsel would state their appearances, please.
Your Honor, Darren Devaney on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Mr. Dicus Saltzman, who does appear from the Butler County Jail. Judge, I would announce this time on this case 23 TR 3035 to the charge of driving while suspended. My client will enter a plea of guilty. And Judge, the sentence agreement recommendation on this case would be a $100 fine, which is the minimum, a cost, and then a 6-month controlling sentence. And there will not be a request for probation, but the request will be that this run concurrent with a felony case that he just had at 11 o'clock with Judge Rickey, and he was sentenced to serve that time in prison.
Okay. And were these the terms of the agreement?
Yes, in regard to 23 TR 3035, Your Honor.
Okay. Sir, could you tell me how to pronounce your last name?
Dicus Saltzman.
Okay, Mr. Dicus Saltzman, have you heard what Mr. Patterson told me?
Yeah.
And is it correct you're pleading guilty to driving while suspended on or about, looks like July 23rd of 23?
Mm-hmm.
Okay, if you could answer in words, please.
Yeah.
Is that a yes?
Yes.
Thank you. You understand you have a right to a trial on this if you desired one?
Yes.
Have you had sufficient time to discuss this with Mr. Patterson?
Yes.
Has anybody forced or made you in some fashion against your will to enter this plea?
No.
Are you under the influence of any medications or intoxicants at this time?
No.
So as this is a guilty plea, Mr. Dicus Saltzman, on or about July the 23rd of 23 in Butler County, were you driving on a roadway or highway in Butler County while your license was canceled, suspended, or revoked?
Yes.
I find that the plea is knowingly and voluntarily entered with the advice of good counsel and find him guilty of that offense of driving while suspended. Is there any additional, any additional arguments in regards to sentence?
No, Your Honor.
Judge, the only additional thing I would say is, again, he had 2 felony cases since he's been in jail. He's been in jail now since April, I believe. And he was sentenced by Judge Crum on 1 felony. This morning, he was sentenced by Judge Rickey on the other. Judge Rickey, I understand, did order he served that time in prison. I don't know what that sentence was. Mr. Devaney might know for sure what the length was. But we're asking the court to run this concurrent with that felony. He'll be on parole, of course, after he serves whatever sentence that was. And so we'd ask court to run it concurrent. Thank you.
All right. What was the nature of these felony charges before Judge Crum and also Judge Ricky?
Your Honor, it looks like the case in front of Judge Ricky appears to be the charges. I believe it was amended, and he pled to attempted abuse of a child. In that case, the other case, and again, in front of Judge Crum, it looks like those charges, he pled to an attempted aggravated assault.
And without giving names, were these victims that are involved in any of these cases today?
One moment, Your Honor. Yes, the clerks who appear here in the courtroom. It's basically an ongoing drug out domestic conflict, and there's been violation of PFAs, a number of different charges, including the abuse of a child charge. So this is.
What's the length of the charge that he's been incarcerated on, and was he given jail credit that would include any time that he's been here in this jail?
Judge, I apologize. I can't answer that. That just happened at 11 o'clock, and we don't have the notes or anything updated as of yet before the docket started. But I do know that he was sentenced to prison this morning to serve his DOC sentence. And to be honest with you, Judge, the clerks who are here were in court. They would probably know at this point more accurately than I would.
Well, Mr. Patterson, do you know what the length of the sentence was?
It was an in-court hearing, Judge, so I could not attend. So I do not know. And I spoke to my client this morning, but I haven't spoke to him after the hearing.
It was 34 months.
34 months?
Yeah.
Did you get jail credit, and what time frame did you get jail credit?
I don't know if I got jail credit or not.
And Judge, under the new Supreme Court rules, or I guess cases, one of them State versus Irvin, it doesn't matter on the credit for time on which case it goes to. Each case gets that credit, even if it's double credit. So because he's been awaiting trial on this case also, he would get credit. It's just the current law.
Okay, so concurrent versus consecutive, you're indicating would only be from the date of the sentencings?
Yes, Judge.
Okay. Mr. Devaney, any disagreement with?
I think there's been some remedial efforts with regard to that jail time credit estimation, but I will looking at the attempted abuse of a child case in that PSI. On that case, he was assessed 163 days of jail time credit on that case.
Okay. Very well. Mr. Dr. Solzman, is there any statement you'd like to make in regards to the driving while suspended charge?
No, sir.
Well, I will impose the 6-month sentence, a $100 fine, and I'm not placing you on probation. However, it will be concurrent with the prison sentence that you're ordered to serve before Judge or on Judge Ricky's case. Attorney's fees will also be assessed to you, and those amounts will after 30 days, go to collections. So if he's serving 34 months based upon the jail credit he has here on this case, he will have served his sentence well in advance of his release on a 34-month sentence, even if it's he's granted parole at a later date. I can't imagine that he would give. Looks like he should have over 200 days of jail credit.
Approximately, Your Honor.
Okay.
Like 260.
Okay. Well, you get credit for the time that you served in jail in this case, and I'll make that one concurrent with the felony case Judge Rickey sentenced you on. So that should take care of that matter. In regards to 25 CR 337, what is the plea in the agreement on that case?
Judge, this would be again a plea of guilty, violation of protective order. The agreement would be that there be no fine. He pay court costs, court to determine attorney fees, and that it be a 1-year controlling sentence, and the agreement is to recommend concurrent with his felonies.
Okay, that was, is the victim in this case the mother of the child that was the victim in the case that he was sentenced on?
Everybody's shaking their head. Yes, Judge.
They're nodding. So I'm taking that as a yes. Mr. Devaney, is that your understanding of the agreement?
It is, Your Honor.
All right. I will. And is that a guilty plea?
Yes, Judge.
Mr. Dika Solzman, it's been indicated you're pleading guilty to count 1, which is violation of a protective order, a Class A misdemeanor. Is that your intention?
Yeah. Yes.
Have you had sufficient time to discuss this with your attorney?
Yeah.
Do you understand a plea of guilty, you'd be waiving your right to a trial? Do you wish to do that?
Yes, sir.
So on or about June the 5th of 2025, and while you were or the victim was in Butler County, that victim being an individual by the name of Sidney Clark. Did you have a protective order? Was there a protective order from a district court for you not to contact her?
Yeah, there was.
And did you contact her? And this, looking at the affidavit, it appears that you did so through another individual while you were at the Butler County Jail. Is that correct?
Yeah.
I do find that the plea is knowingly and voluntarily entered with the advice of good counsel that a factual basis exists, and do find Mr. Dika Solzman guilty of that being a Class A misdemeanor. The other 2 cases which also appear to be involved with that victim, that being case number 25 CR 184 and 25 CR 186, are dismissed with prejudice pursuant to the agreement. And I'm not sure now, Mr. Devaney, did I ask you if you agreed that that what Mr. Patterson recommended was the agreement between the parties?
Yes, Your Honor, that's the agreement.
All right. All right, I will hear. First of all, I'll allow the victim to speak. That she is an adult, appears to, based upon the date of birth, would have been an adult at the time of the offense. So, Ms. Clark, I will hear you in regards to any statement you wish to make in regards to, and I have to be careful when let's make it an appropriate statement. Not that I think that you would be inappropriate, but I've had other individuals that were. So I need to put that in my recitation at this point. So any appropriate statements you wish to make in regards to sentence on this particular case?
First, I just want to say it wasn't just one time of violating the PFA. There's multiple in Wichita that are dropped, I'm pretty sure, but it's been multiple times. He has a pattern of violence towards me and my son. I just hope, I don't know, I want you to take into consideration when you sentence him. It's a reoccurring pattern.
All right, thank you. Mr. Devaney?
Your Honor, I kind of want to echo the victim statement here, which is obviously this is a kind of an amalgamation of a number of different cases that have evolved out of a long-term stalking and harassment violence. There's domestic battery, violation of protective order. You have aggravated assault. You've got attempted abuse of a child, pleas. This has resulted in him going to prison now for 34 months. And certainly hope that this is the end of everything, but he'll have post-release supervision and all of those matters. And I certainly think that these cases are serious and recurrent. And on top of that, you throw in a traffic charge on top of it. So there's just it's just been a long drawn out process for the victim in this case. And I say victims plural because it is not just this young lady, it's the child as well and her extended family that's been dealing with this. Regardless, we finally, I think, have closed down his cases and got him to where he's going to be going to DOC now. And so the plea agreement that we have here with regard to packaging this up and maybe closing out these cases, I think is a step in the right direction here today. I'd ask that you adopt the recommendations we had for the plea agreement between Mr. Patterson and our office. As far as jail time credit, we're going to have kind of a algebra to do, I think, with regard to that, but we will get that calculated and have that reflected in the journal entry.
Thank you. Mr. Patterson?
Just briefly, Judge, we've talked about a 32 or 34-month sentence that he has with Judge Rickey. He was sentenced by Judge Crum, but in that case, he was diversion eligible, received diversion. I mean, not diversion, probation. But of course, since he's serving this 32 or 34 months, probation is probably impractical. So that I would think there is going to be a revocation of that case for probation. And it's consecutive by law. So it's much longer than just the 30-some months, Judge, that he's probably going to serve. So at this point, just ask the court to adopt the recommendations. Thank you.
Mr. Dr. Salzman, is there any statement that you'd like to make before I pronounce sentence?
And I mean, I'd contact her because I just wanted to just tell her I was sorry. And I mean, I wasn't trying to mean no harm or anything. And you ain't got to worry about me ever trying to contact her again. And I'm sorry for what I did. You know,
Anything else?
that should be it.
It's not very often a defendant, when they're hearing the factual basis and hearing the attorneys, is smiling in regards to at their sentencing. And you've been doing it quite a little bit, particularly when the victim was stating and otherwise. What's so funny about this?
That they lying on me. That's what's funny to me. They don't even know me. Like her parents, like they half the stuff they saying ain't even true. Like I know what I did to my son. But I mean, you can believe him if you want to. I ain't tripping.
Well, you've pled guilty to an offense here today, and I went through facts, and you acknowledged those were correct.
Like, I mean, I'm not worried. I'll do my time. I'm just like, I've had to hear these people talk about how bad I am, all this and all that. I'm just done with it. Like, I ain't really tripping about it anymore. Like, they've tried to make me sound like I'm a bad person, and I'm not. My family knows I'm a good person. My family knows I love my kids. And it's just funny to me because, like, she wasn't saying none of that stuff back then. And her parents weren't even in the picture. Like, she lived with my parents, and my parents were taking care of my kids. Her parents weren't even in the picture or anything. So I just find it funny now how they all switching up. How she's switching up.
Well, sir, you've had judges tell you not to have contact with her, and you seem to have just went through those
I
orders.
contacted her one time. I don't remember any other time that I've contacted her other than when I called her in jail. I really don't.
All right. I'm ready to proceed with sentencing. Was there something else that you wish to state before I make sentence?
No, sir.
For the offense of violation of a protective order, a Class A misdemeanor, person misdemeanor, I sentence you to 1 year in the Butler County Jail. I order court costs and attorney's fees to you. I have considered a fine. I'm declining to do that. I don't believe you're sorry for what you've done. Just watching here today.
I'm sorry for what I did to my boys, but I ain't sorry for what I did to her. She switched up. I honestly could care.
All right. Thank you. I'm ordering that this case run consecutive to the other cases that you've been sentenced on. If I understand the general practice, you will, and you'll get credit for time served that you're entitled to on this case. That may be cross some of these other cases, but if there's any other additional time, I believe the general practice is for the person to go to the penitentiary, and once they've served their sentence there, if the misdemeanor hasn't been modified, then just come back to the county jail to serve their time. And that's what I'm intending to occur. The court can hear modification motions at that time, but based upon what I've seen here today, I don't think he is a good risk, and I don't think he's. I think he has. It does present a danger to the public as well, certainly to the victim here. So I think he needs to have a penalty for what he did in this case, and making this concurrent with everything else doesn't do that. Counsel, any questions or other matters that I need to make a rule on?
No, Your Honor.
Nothing further, Judge. I just want to make sure we get credit for time. I'm sure Mr. Defendant will send that to me.
Right. And I think I already stated this, but 25 CR 184 and 186 are dismissed with prejudice pursuant to the agreement.
Yes, Your Honor.
Nothing further than this matter is adjourned, and he can be taken to serve a sentence.
All right, how about Mr. Squire's show cause? Are we ready on that, or do you want to take up someone else?
Well, that's my last one, Judge. I don't know if I think you ordered him to be at the courthouse.
He is here.
I don't see anybody at the courthouse.
Well, he's been here most of the morning. Deputies, if you're there, could you go get Mr. Squire? I know he left at some point, but I certainly hope he came back. He hung out for a while. There he is. All right. Did you need a breakout room with him, Mr. Paul, or are we ready to go?
Judge, we were just set for disposition today. He already admitted to the violation. You were waiting to see what happened in his Butler County case.
Okay.
Before we proceeded on this one, Your Honor.
All right. Let's see. 12-5. He started the warrant to show cause. He did waive his right to evidentiary hearing and stipulate to probation violations. He was found in violation, and as you said, dispo set till today. And Miss Morgan, you're here on that case, is that right?
Yes, Your Honor, I'm covering for CSO Tarones.
And I may have this, this may not have been the one I was looking at a while ago, but did he get put on probation in that case?
He did, Your Honor. I received an email yesterday from, I don't recall the PO's name, indicating that he had been placed on probation. If the court did the same in this matter, they requested that he be supervised by one officer and that supervision be transferred over to Butler County.
Mr. Squire, do you still live in Butler County?
Yes, ma'am.
Okay.
Your Honor, I guess from the state's point of view, I don't recall. I think he has served some time on this case. A 6-month underlined sentence. At this point, if the court is inclined to grant him a reinstated probation, or I guess the court hasn't revoked his probation yet, just been a stipulation that he has violated the terms. If he's placed back on probation, Your Honor, I believe it would be appropriate that that probation time period start over for a supervised time period of 12 months. This was no contest to a third driving while suspended. Additionally, it appears that a special condition of probation would need to be no contact with Jennifer Davis or her significant other. I don't know that I have his name, but I know that was one of the issues as far as there being contact there.
Okay, this is Mr. Squire. I don't remember Jennifer Davis involved in this, or was she?
It had to do with the alleged law violations.
Oh, in the Butler County? Okay, I'm with you.
Yes.
May I say something?
And that his probation be transferred, if the court places him on probation, after restarting it, that probation be transferred over to Butler County for supervision with his current conviction there. And that he not only comply with all standard and special conditions of probation in this case, but as an additional special condition that he comply with all of those in his current Butler County case.
Mr. Paul?
Judge, I think those recommendations are appropriate.
Okay. Mr. Squire, I saw somewhere in your file that you've gotten involved with methamphetamines. And that seems to be what's made you kind of start down a different path. Miss Morgan, is that correct? He's gotten into meth?
Your Honor, it looks like he was sentenced on yesterday on BU 25 CR 338, which was possession of methamphetamine.
And is that a felony? Surely that it would have to be a felony probation.
Yes, Your Honor.
The email did indicate to me, and I'll try to pull that up, that he was placed on mandatory Senate Bill 123 treatment.
Okay, is that through corrections or is that? Community
I
corrections.
believe,
Yes,
let me
it-
see if I can pull that up.
Judge, usually Senate Bill 1 through 3 is through community corrections.
yes, Your Honor.
Yes. Mandatory
I-
community corrections. Mr. Squire is placed back on probation in this case, and this was from Marcy Terrens. Placed back on probation in this case, she would request he be supervised by community corrections and have one probation officer. She believes that would be the best at him having a chance at successful probation.
All right. Ms. Morgan, anything further from court services?
Nope, that was her recommendation.
Okay. All
Oh,
right.
sorry.
Well,
I wasn't sure you had all that, Jessica. My apologies.
all right. Well,
No problem.
Mr. Squire, I know that I've been seeing you more lately, but I also know that in recognizing the work you had done as a foster care provider and some other things before you started down this criminal path, I was wondering what had happened to make you appear to change, to be from this squeaky clean farm kid, or at least to me, you look squeaky clean as a farm kid or rural kid, to all of a sudden all this other stuff going on. And I think the meth would explain that.
Well,
And it's really sad to see that happen. Now you've put yourself in a position where you've got an addiction that's going to be really hard to kick. But you're going to have to do that to get back to who you really are, don't you think?
and I've been clean for 7 months now.
Well, thank goodness for that.
What happened?
Don't say a word. Don't say a word.
Okay.
James, don't say a word. Thank you.
All right. He's trying to protect you, but I understand you're trying to explain. So I just want to see you get straightened out. So I am going to order that your probation to court services be revoked. It will be reinstated for 1 year from today through community corrections. You are to comply with all the Butler County conditions in that felony corrections. I can't emphasize enough, no meth, no alcohol or drugs to substitute the meth with. No contact with Jennifer Davis, whatever that's about.
How am I supposed to see my daughter?
Is that your daughter, Jennifer Davis?
No,
Is that
she has
the
my
mother? Is that the child's mother?
Yes.
No, that would be I mean, if there's an order for some type of parenting time, then that needs to be all that generally the orders would permit contact for the exchange, and any kind of contact would have to be solely related to the parenting time.
And
the child is nothing outside of that.
That's completely agreed.
All right, but if you're going to keep using meth, you might not need to stay away from that child. But I'm gonna just hope that you're going to follow the court's orders and get off that meth, stay away from that meth. I know it's not easy. I've seen a lot of people struggle with that, but you've got to do that. Call community corrections as soon as this hearing is over and let them know that I'm going to run this concurrent with that supervision. Mr. Dean, what else do I need to order as conditions of probation in this case?
And just for clarity of the record, Your Honor, the court's reference to concurrent with that probation is that both probations run at the same time.
Yes,
However,
thank you.
if the Butler County case announced on the record that case was consecutive to this, as they were sentenced after, the actual jail terms or prison terms run consecutive.
Yes, and I don't know how much of that you're familiar with. Mr. Paul can explain that, but your sentences, if you have to serve your time, will be consecutive. You'll serve one sentence, then you'll serve the other. But as far as supervision, I don't want you doing two different officers. I want one officer supervising you for both cases. So thank you, Mr. Dean, for getting that clarified.
Yes. And if you successfully complete probation, you never have to look at any of that time.
And that's what you really need to focus on. Don't violate it so you don't have to do any of it. All right. All prior conditions will still apply in this case. Okay.
Thank you, Your Honor.
You're welcome. If there's nothing further, Mr. Squire, you're excused, but you stay away from people that provide alcohol and illegal drugs. You don't need to Be tempted
James,
like
good
that.
luck to you.
Thank you.
Is your next one Luis Hernandez?
The last one, yes.
Set for sentencing. Do we have an alcohol and drug evaluation?
No, we do not.
Oh, you did not want to tell me that today.
I understand, Judge.
All right.
Go ahead and call the case and I'll give you the story, okay?
Okay. We are on the record in GW 2024 CR 205, State of Kansas versus Luis Roberto Hernandez, County Attorney Jill Gillette for the state, Attorney Richard Paul for the defendant, who also appears in person.
Grizzly.
Appearing in person on order of the court. Now, the second thing is he was ordered to be here in person, and he was ordered to be here with his evaluation in hand, having had this thing continued repeatedly to get the evaluation. Court recalling that he was to get it at a facility next to your office, Mr. Paul, and you said that they were pretty quick at turning them around. So here you go, Mr. Paul.
Well, thank you, Judge. Mr. Hernandez did try to do all of that. Unfortunately, he doesn't have an ID, so they wouldn't let him do an eval.
All right. Mr. Hernandez has repeatedly denied my order for whatever his excuses to get that evaluation done, and that goes clear back at least till October, I think even long before that. In any event, officer, I'm ordering that he be taken into custody and that he sit in the county jail until he gets that evaluation done. And I will order whoever you can get in there to get in there and do it. Deputy, can you hear me at the Greenwood County Courthouse?
Yes, ma'am.
Take him into custody with the order that he gets his drug and alcohol evaluation done in the county jail. And Missy, when can we do his sentencing?
I'm not sure how far you want to go out because I don't know how long it'll take to get that done.
I don't know either. Miss Gillette, any guesses? Estimates?
I was just texting the jail and the jail liaison for mental health and treatment stuff. So I don't know till they answer me. But I would say let's put him on for a status on like a 3:30 docket. When's our next one, Missy? We have one January 20th, which is this coming Tuesday. And
that's probably too soon, I would think.
Well, then we'll know at least if it's scheduled.
There you go. You've said status. So for status 3:30 this coming Tuesday, which is what?
The 20th, January 20th.
All right. Mr. Hernandez, you have been a very difficult defendant trying to get this done. Maybe now it'll happen. Now, counsel, I want to make sure that someone contacts the appropriate agency. Will it be Crosswinds, probably Miss Gillette, that will go in to visit him?
I'm going to check with Crosswinds. I don't know. Sometimes we have SAC, sometimes we. So I was going to text.
Well, SAC is the one next to Mr. Pa's office.
Mm-hmm.
So, but whatever you can do, and technically I'll have to get Judge Ricky's prior approval for if we have to make the payment directly. I'd like to put it in the journal entry that the defendant is responsible for that directly, but whatever we need to do to get that evaluation. So this defendant, actually it's been since March 4th that he was ordered to get that evaluation. March 4th of 2025, and we still haven't gotten that evaluation. And we have 1, 2, 3, 4, 5, 6. This is about the 7th hearing. All right, so Ms. Gillette, I'm going to put that in your hands to make sure that someone gets called and that you and Mr. Paul coordinate to get that done. And we'll look at it again. I like your idea. The more I think about it, Ms. Gillette, that we do a status on January. You said January 20th at 1:30, right?
Yeah,
3:30.
At 3.
3:30, yes.
3.
3:30. That's just 4 days from now. Okay. All right. Go with the officers, Mr. Hernandez. Don't get into any more trouble. That enough. Officer, do you have him?
Yeah, they're.
And I don't want him to be busy with something else and let him walk out the door. That was Deputy Lazar that was in charge there.
Leonard.
Oh, that was Leonard. All right.
He has him now.
All right. He's in your hands, Deputy. Okay.
Yes, ma'am. I'll take care of it.
Appreciate it, sir. Now then, who do you want to take up next, Mr. Paul?
No one.
No one? That's your last one?
It is. And thanks for asking me. And when you asked McClendon if it was okay if they went first, you didn't even ask me.
I sure am.
I know where I rate.
I really intended to put you at the front of the docket, and everybody started having all these double bookings, and I thought, for once, I'm gonna let you get up front. But
That's not a problem. I appreciate. Well, I really wanted to go last anyway because I knew what was going to happen with Mr. Hernandez, and I wanted that at the last of the docket.
Went into a not guilty plea. Disorderly and
Not guilty, I am. Coffee, I went and got coffee. Wanted hot water, and he gave me lukewarm water, and then I bought coffee. And then got that.
1 second, Mr. Sorrell, please.
Yeah, okay, mute.
What do you want to say regarding bond?
My client is like I'm supposed to go bond, Your Honor. He promises to come back to court. He's anxious to resolve this matter.
Jeez. The allegation is he was making a scene in Culver's, telling employees he was going to kill and stab everyone in the restaurant.
That isn't true, Your Honor. It was not
Mr.
true.
Sorrell,
I did
Sorrell,
not. You can
Mr.
watch.
Sorrell,
I have to
please,
be out today to go to.
please,
I want to talk.
please,
I have to go to
please.
probation today.
Please,
Everything's
sir.
been going well. I did not do that over a cup of coffee.
Okay. I just told your lawyer what the allegation is.
Well, I need personal bond to get out to go to probation. Everything's been going well, Judge. I live in Taylor now. I was over here I had to come over here to see friends too. And yeah. Over a cup of coffee, I'm gonna do that. Yeah, right.
All right, I'm going to tell you the bond conditions first. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No contact with Woodhaven Culver's employees, no contact with prosecution witnesses. You cannot enter 23300 Allen Road in Woodhaven or any other Culver's restaurant. You're not to possess any firearms. You cannot possess dangerous weapons.
Good.
7,500, 10% is the bond.
What?
I will give you a court date of January the 28th.
I can't go to county.
January 28th at 10:30.
I need medicine. I can't go to county. Man. I need medicine. What are you sending me to county? I can't pay the bond.
Put medical on there, Heather.
I want a
Thank
personal
you.
bond, man. No.
Okay, Judge.
I want a personal bond, you asshole. What is up here? You never give me personal bond. You're an asshole, man.
All right, I'm an asshole. That's
You
okay.
won't give me personal bond.
All right, let him shut the thing off. Will you guys? I've had enough of this.
Back to county.
Oh, wait a minute. That's it.
Judge, you want me to remove the camera?
Well, do I have another one with you guys, Wilson, or is that in here? Oh, yeah, you shut the camera off. Jermaine Sean Hall Jr., 25, G306346 A and B. Name, sir? What do you have to say, Mr. He's missed at least three times. He thinks he's walking out of here with a personal bond too.
Well,
What happened? Was he in custody? Was he in the hospital?
no, Your Honor, he just made an honest mistake. He thought the court date today versus yesterday.
Yeah, 3,000, 10%. You cannot leave the state. I'm not changing my mind. He's missed three.
You change your mind. What the court considered 2,000, 10%, he
Nope.
has $200.
Nope, I'm not.
He's got $220.
I don't care if he's got $220. I want 300. He's missed three times. He's not going to keep doing this. You want to keep delaying this until the day? That's okay. January the 29th at 9:15. You cannot leave the state. You cannot violate a law. You must appear in court as directed. Grow up, okay? Grow up. That's it. He'll let you make some calls. Be glad to let you make some calls to come up with money, but I'm telling you, I've had it with you. You understand what I'm saying? Good.
But I haven't had it with you. No, sir. No, sir. Thank you so very much for hanging out with me tonight, ladies and gentlemen. It's been a pleasure presenting these cases from the daily dockets of today. And just so you know what I have planned for tomorrow, Mr. Moz was back in front of Judge DeSanto again yesterday, like just yesterday. And it was a nice long 45-minute discussion they had. So we're going to review a lot of Moz. So get ready, ladies and gentlemen. We're going to have a Saturday full of crazy. There's going to be Mr. Moz and a lot more. So come on by tomorrow morning, 11 a.m. Central Time, noon Eastern Time for brunch with Wolf and the Pack. We'll all be here. We'll have court to watch, and it'll be fun. But for now, I'm going to say, have a good night, ladies and gentlemen. I am your Lone Wolf Usul, and I am out. Peace. I'm not even kidding now. It's like an hour and a half composition to the last year of Crazy Moss. And it's gonna be amazing. It's gonna take up the second half of the show. So we'll have like 30, 45 minutes, maybe even an hour of something before we get there. But man, you gotta be here. I'm telling you, you're not gonna wanna miss no Moss. Not this. No sir. No ma'am. We'll see you then. Thank you, ladies and gentlemen. Thank you very much. It's been a long week for me, just like Judge McNally. I feel Judge McNally's pain, man. I really do. There's nothing else to see here. Go home. Have a great night. And thank you so very much for hanging out. It's been a pleasure. Arr!